I don't see her.
No, not yet.
I don't see her yet.
Okay, so either give me a second or two and I can text her and find out if she's going to be joining us.
Yeah, go ahead and text her.
I'll do that.
It's cool.
Let's see.
In the meantime, while we're waiting for that, everybody put your name in the chat, or your name should be already be there, and just say where you're from. Whatever else you might want to say. I'm Teresa from Long Beach by the way of Bellflower. See San Pedro. I know Santa Clarita's in the house.
That's right.
Teresa, whoever has the 949, I keep throwing them in the waiting room because they have to put their name there. So don't let them in unless they are able to rename it.
They are. I agree.
Okay, I texted her and I hopefully she'll
I'm
respond. But in the
949.
meantime, I would like to introduce our board member and also a member, director of the California Association of Realtors and a director of the Southland Regional Association of Realtors, our colleague Renee Roque for the mission statement.
Thank you, Mr. President.
Renee, you have to unmute
You're
yourself.
muted, Renee. You get a do-over.
Thank you so much. I get a do-over. Thank you. Lesson 101, Zoom. Here we go. We are a network of Black realtors advancing as business leaders in the industry and in our communities. We are advocates for increasing Black home ownership. We fully embrace our members by acknowledging, mentoring, supporting, and developing them into industry leaders, both locally and nationally. And that is our mission statement. Thank you, Mr. President.
Okay, I just received a text response from Victoria saying that she thought the meeting was at 11. So I'm going to put somebody on the spot. Who would like to be put on the spot to inspire us this morning or give us a word of prayer, whichever you prefer?
Kevin.
Kevin has his hand raised.
Please go for it.
Unmute yourself, Kevin, and go ahead.
Hello, everybody. I'm Kevin Caleb. Most people know me as Coach K for you. So everything I'm doing in my life is for you, other people, and in this moment, I volunteer to do the work that I do. Heavenly Father, we just come together and thank you for this time to fellowship and learn with one another. We know that you're guiding all of our steps and the reasons that we are doing the things that we do. Now, allow your word, your messaging, your guidance to bring forth the learning for today, everyone on the call, and allow us to reduce ourselves to receive the messaging that we will hear from you, to the people guiding and leading. And we thank you in advance. In Jesus' name, amen.
Amen. Thank you very much, Kevin. Appreciate you stepping it up. Okay, with that, I'll introduce our President-elect 2025, and that is Ms. Teresa Miller. Thank you so much for putting this together. We are excited. The new news is that more recently, within the last couple of weeks, Teresa stepped up and volunteered and was elected unanimously to be our president-elect, and so was Renee Roque. She was unanimously elected to be our secretary for 2025. So with that, Madam President-elect, you are on.
Thank you so much, President Mel. It is an honor and a privilege to be here. And I have the honor of introducing the most inspiring, the most beautiful person that I met in a very short period of time. I feel like she could be my daughter. So I want to do her justice. I want you guys to understand who is about to speak and the information that you're going to receive. So I'm going to read her entire bio. Andrea Barnes is a native of Madison, Mississippi. She received her formal education in the Madison County Public School System. She earned a Bachelor of Arts degree from Tougaloo College, a Master of Business Administration from Jackson State University, and a Doctorate of Jurisprudence from Thurgood Marshall School of Law. Andrea is licensed to practice law in Mississippi. Andrea is the director of the Heirs Property Campaign for the Mississippi Center for Justice, a nonprofit public interest law firm. The Heirs Property Campaign provides legal assistance and community education to families around the state to preserve ownership of their land and maintain their legacy. Prior to joining the center, Andrea practiced family law, estate and probate administration, and personal injury litigation. Andrea's background also includes working as a law clerk with the Circuit Court of Hinds County, Mississippi, a prosecutor with the Hinds County Attorney's Office, and as a public records officer and staff attorney with the Mississippi Department of Corrections. Andrea has also served as an adjunct professor at Tougaloo College, educating, inspiring lawyers about litigation and trial practice. Previously, she served on the board of directors for the Spencer Perkins Center for the Reconciliation and Community Development. Andrea is a member of many professional organizations and associations, including the Mississippi Bar, Magnolia Bar, Metro Black Women's Lawyers Association, and others. She has received numerous accolades and recognitions by the profession and community. As an entrepreneur, businesswoman, and attorney by trade, Andrea is truly a servant leader whose life reflects her commitment to her faith, integrity, and justice. In her spare time, I don't know where she finds that spare time, Andrea enjoys spending quality time with her family, gardening, and traveling. So it is my honor to introduce to you attorney Andrea Barnes.
Thank you. Good morning. I'm going to try to share my screen really quickly.
You guys are going to be in for a real treat today.
Give me a second if I can just. Okay.
There you go.
All right. Can everyone see the slides? All right.
Yes.
All right, so I'll say good morning again, President Wilson, President-elect Teresa Miller, Miss Yolanda, those in leadership, and just all of you on the call on today. Thank you so much to the California Association of Black Real Estate Professionals for extending the invitation for me to share with you today. I'm so humbled and honored to speak on the topic or a topic that is near and dear to my heart. In our time together on today, of course, we're going to be discussing heirs property. And if any of you are like me, growing up in a rural county here in the South in Mississippi, had never heard of the term heirs property, but had always heard the elders speak about family land and what one could do with family land. So we're going to be talking about today family land and what that means. Now, of course, in lawyerly fashion, I'll have to put this disclaimer out here that in terms of our time together today, of course, it is educational purposes and not considered advice, because I don't want anybody to say I'm, not practicing law in California, right? But we're gonna just share today. Have a little agenda that I want to go through in terms of like our roadmap for today and what that's going to look like. And I specifically chose this particular picture because when I saw the backdrop, I've been to Rancho Cucamonga, I think California, sometime in March or May. And I remember going through and seeing what we see here. And so I was like, okay, I think this will fit for our time. But I want to just provide some context in terms of our conversation today. Now, of course, I'm an heirs property practitioner. And as President-elect stated, I'm licensed, of course, to practice in Mississippi. But as an heirs property practitioner, I consider myself a protector of legacy, right? And so what we're going to talk about today is about a phenomenon called heirs property and how it's a barrier to title and how we overcome those barriers and deal with those complex issues. And so in order for us, I think, to really have a conversation of substance today, I think it's important that we provide some kind of context about why heirs property is even important, why it's even a conversation for today. And then we're going to talk about how we are able to protect and prevent heirs property. And then lastly, how you can help stabilize land ownership for economic security, because I loved your mission, right? As I listened to it this morning. And so I think we're aligned, right? In terms of our mission and our core values. So when we think about African-American land loss, one of the things that we know about land is an asset. Another thing that we always know about land is, one, they're not making anymore, right? So what we have is what is. But what we know about land ownership is that for many, land ownership is this primary pillar of how one is able to build wealth, have independence, have freedom. And what we also know about land ownership, if we just look from a historical perspective, land ownership was one of the main battlegrounds of racial conflict, especially in the Southern Black Belt and in Mississippi specifically. If we look at a time frame between Reconstruction and 1910, African Americans amassed 15 million acres of land. We know that as a result of racism, discrimination, lynchings, Jim Crow violence, a lot of African Americans left the land to actually seek better opportunities in northern, more urban centers. And so thus we have the Great Migration. But if we think about the land, and if we think about farmers, and I always have to throw in our farmers whenever I do a presentation on heirs property, because this particular picture, and I always choose it, reminds me of my why and why I do this work. My grandfather had an 8th grade education, was a farmer. And so as I grew up, saw my grandfather own the land, working the land. He had a tractor very similar to one depicted in the picture. But the great thing that I love about my grandfather is that, notwithstanding the fact that he didn't have a high school diploma, nor did he have a college degree, he did have a vision for his family of ending intergenerational poverty and building wealth. And his vision for his family in reference to doing that was through the ownership of acquisition of land. So to my grandfather, land meant something. It meant freedom. It meant, the ability, right, to have your own. It meant legacy, meant something, right? The ability to leave something to future generations meant something. And so I do this work to help others be in a position to protect their legacy and then be able to preserve that and leave that and structure it in such a way that they have something to build generational wealth from. And so when we think about Black farmers, if we think about this statistic, it says in 1910, Black farmers own more than 16 million acres of land. And then the most recent agriculture census, it was done in 2022, and now that figure is about 5.3 million acres. So we've gone from 16 million to now 5.3 million. And so that's a lot of land loss over a short period of time. If we really just think about the space between that 1910 and 2022. Now, when we think about this land loss in the past and where we are currently, this war has raged in reference to deed of title, and has actually dispossessed 98% of African-American ag landowners in America. And so what does that really mean, right? At the end of the day, what does that mean? What that means is they've lost 12 million acres of land in the past century. And so in 1997, this particular land base was about 7.8 million acres, which was rural land that was valued at $14 billion. And so when we talk about this land loss among African Americans, what we recognize and understand is that this was a result of one, a lack of estate planning that resulted in cloudy titles, fractional ownership. But if we put a pin there in terms of lack of estate planning, a lot of the clients that we see here in Mississippi have that lived and learned experience as it relates to land. So when we start talking about land ownership, and planning for the next generation, a lot of elders don't trust the legal system. They don't trust lawyers. They don't trust judges, right? Because those systems that were put in place historically to be able to assist, they found themselves, right, on the opposite end of justice and equity and equality and what that looked like. So we have a lot of people who, quite honestly, even today, notwithstanding that we had COVID-19 to launch in 2020, who still are adverse to estate planning just because of that lived and learned experience. And so this, quite honestly, when you don't plan or when you fail to plan, people create heirs property. I think another reason that we have had land loss is people don't know what they don't know. And so there is a lack of education as it relates to land ownership, one's ownership interest, the responsibilities that go that are birthed from ownership, maintenance, property taxes, all of those things. And so people just don't know what they don't know. And in our culture, quite honestly, you have a lot of people where there are a lot of myths in reference to heirs property and what that looks like. And so oftentimes within families, people may say, well, mom said or granddaddy said the oldest inherits, right? Or if you're like my granddaddy, he was like my youngest twins have a right to inherit. But one of the things about my grandfather is I could not get him to estate plan, but we'll talk about what I did get him to do. But I did not get him to draft a will. So these are the reasons why heirs property has now become this big issue, this problem, not just in Mississippi, not just in the South, but it is a nationwide issue, right? Heirs property is prevalent in pretty much every state in the United States. I put this illustration here because it was a study that was done by Rebecca Dobbs and Cassandra Gaither in 2023, and it's actually published in the Journal of Rural Sciences, but it actually provides a look at an estimate of heirs property for parcels for every county and census tract in the United States. And I thought that was very interesting in reference to this particular slide, and I wanted to make sure, and California was mentioned, right? So as you see, California has some circles. So California was mentioned, and in terms of property or parcels of heirs property, I think this particular study indicates that in terms of acreage, it's about 141,000 plus, I guess, acres of land that they believe is in fact heirs property in the state of California. I will note that as it relates to heirs property, it's difficult to kind of quantify because people use different methodologies in terms of how they come up with the numbers and what that looks like. Different counties and have different terms that are used. So the nomenclature is not the same from county to county. There's no uniformity as it relates to how one identifies heirs property. In one county, in San Bernardino, they may identify it as a state of or et al. In another county, it may say heirs. So every county doesn't identify it or term it the same. Additionally, sometimes there is different levels of access to trying to even get the information in terms of the parcel. So some counties have online access. Others, you have to actually go into land records and comb those records to be able to identify it. And sometimes you can easily log in where others may require a fee. So there are a number of reasons in terms of why the numbers may be different when you look at various studies as it relates to the quantification of heirs property. But this slide is here basically just to acknowledge that I'm talking to today or sharing with persons who practice in the state of California, and we do know that heirs property does in fact exist in your state. Now, when we think about heirs property, right? Well, what is this term? And of course, I told you that for me, I always just heard of the term family land, did not know until I became a lawyer that of the legal term heirs property. But when we think about heirs property is just land that is informally passed down from generation to generation. Typically, when you see heirs property, the property owner dies without a will, and the legal term for that is just intestate. They die without a will. In some instances, they die with a will, and the family never takes it to probate court to transfer ownership. But for our purposes today, we're going to say a property owner dies without a will or other valid instrument transferring ownership interest in the property to the beneficiaries. When that happens, state law determines who has a right to inherit the property. And the state laws are called intestate succession laws, right? So California has intestate succession laws. And so really basically what we're saying here is when let's say your dad and mom had property, and the language of the deed was maybe they owned it as tenants in common. It didn't have the right to survivorship language, which meant if dad predeceased mom, dad owned a 1/2 undivided interest in the property, and mom owned the 1/2 undivided interest in the property. If dad died without a will, at dad's death, we have to determine who has a right to inherit from dad. And state law is going to decide who inherits dad's 1/2 undivided interest. And so when the family fails to take the deceased person's estate or property through court to settle the title to the property, you have what's called a cloudy title, and the land is owned in common by all of the heirs, known and unknown. Now, there is a myth. Some people think that, again, like I say, that they, if they're an heirs property landowner, they own the whole. With heirs property, you own an interest, right? You don't own the whole. You own an interest in the land. And so all heirs own an undivided interest in the land. And so if I wanted to say that, top 5 or 6 things I need to know about heirs property, this is your slide, right? We know that land is passed down informally. As an heirs property landowner, I own an undivided interest in the land. Now, another thing that I think is important as it relates to heirs property is, because you own an undivided interest in the land, let's say, for example, if all mom or dad had was a house, right? And there were 4 heirs to the house. So everybody had a 1/4 undivided interest in the house. You can't split the house in 4 and say, okay, oldest child, you get the front door, youngest child, you get the back door, middle child, you get the left window, right? It's difficult. It's difficult when it becomes, and that's one of the complexities of heirs property, is that depending on what a person left, whether that's a house, a lot, or acreage, you may not be able to divide it. Heirs property then it can become complex. Now, when we think about how we resolve heirs property, how do we unwind the complexity of it? I think we start with education of knowing what our rights and responsibilities are. And then secondly, we speak with a trusted legal professional. Now, we've kind of already talked about how land was lost in terms of this lack of outreach and education and even legal assistance. We had, in terms of history, and there are a lot of documentaries that document this, you have sometimes developers who don't do it the right way, who end up being able to take a family's land. What we've seen as recently is tax sales. Tax sales is also a big contributor to land loss when one is delinquent on those property taxes, and then the property is it's bidded on at the auction. People lose land that way. Adverse possession, eminent domain, foreclosure. So big picture umbrella is heirs property, but all of these things are kind of a subset of that. Quite honestly, we see a lot of people who are facing foreclosure. Let's say you had a husband and wife who may have been on the deed, but husband may have been the only one on the mortgage. And if he's only one on the mortgage and the only one with whom the mortgage company can speak with in reference to the mortgage, if the wife becomes delinquent and paying the mortgage, the wife has a serious problem, right? Typically, the mortgage company is going to require her to actually file some type of direct legal action because the mortgage is an asset of the estate. So you can just have so many different issues that flow from heirs property. What we know about, though, African American land laws is that it adversely impacts sustainable economic development for families in one state. Now, when we started doing this work, right after Hurricane Katrina, we stood up an heirs property campaign to help those landowners who were facing disaster. And so in Mississippi, our disaster most of the times is going to either be tornadoes, flooding, or let's say hurricane. I know, of course, in California, you also face natural disasters, maybe floods, maybe fires. But one of the things that those landowners on the coast did not know, they were trying to repair and rebuild, but because they had heirs property, they did not qualify for governmental service, right? And so since that time, what we've done is try to move people beyond like disaster to helping them stabilize their ownership. So the heirs property campaign is solely devoted to assisting heirs property landowners in Mississippi with resolving those title issues. And we have 3 primary buckets of work. So we protect land legacy by trying to focus on outreach and education. We do simple wills for landowners in Mississippi and have mobile wills clinics. We do file direct legal actions to resolve to protect legacy. But then we also try to preserve the legacy, and that's important. And so we have a conservation team that helps to do a conservation management plan and the like in an effort for families to know what their assets are. Because at the end of the day, the way you preserve and protect heirs property is not just clear the title or resolve the title, but we have to also be proactive to help families prevent the creation of heirs property after you would have helped them unwind all of the complexities, right, of the title when they initially had it. And then you go from there to then further the conversation to say, hey, how can you make income? How can you use the land to make income from the land? So whether that's leasing the land, whether that's timber harvesting, we can get a conservation plan going to identify the assets you have on the land so that the land works for you. And so I think it's changing the narrative of the conversation and not seeing land as a burden, but land as a way that you're able to build wealth. But the first thing we have to teach people is how to unlock the potential that is in the land. Because we service underserved Mississippians, low wealth Mississippians who cannot afford a private attorney, most of our clients, quite honestly, are land rich and cash poor. And so we stand in the gap to try to help them have access to justice, access to the courts, so that they're able to build generational wealth. And so it's all about legacy, being able to leave something to future generations. Now, what I recognize and understand is, depending on where you're from and how you were raised, you may say, well, listen, like my granddad did, I want to keep it heirs property, right? Because I want my family, wherever you are, if you go to California or if you go to New York, you can always come back to great old Mississippi and have a place, right, to call home, have a place to come back to. And that was great. But what my grandfather did not understand is he was really putting the family in a vulnerable position because heirs property is vulnerable. And what we've seen across this nation is that there is an attack on property and property rights around the nation. We get calls from people all the time from different parts of the United States looking at land rolls, trying to identify heirs property because they know it's vulnerable. And they lie in wait, waiting for families to not pay those property taxes or trying to come in and get an interest so then you can force a partition sale. So we're sounding the alarm to say, listen, if you have land, you have something of value, let's start the conversations with our families on how do we protect our most vulnerable asset. All right. And so when we have the conversation about heirs property and what that looks like, I know all of you have probably heard the term probate. And if you were like me before law school, you're like, what does that mean? Right. But it's just the legal process where you go to court, where you manage the affairs of the person who is deceased. Now, when we talk about heirs, a lot of people are like, well, who are the heirs? Because that's the poll star question on heirs property matters, where an heir is a family member who is related by blood, adoption, and or marriage, who may inherit by law. And a lot of times in Mississippi, when we're doing outreach and education, people get stuck here because, you know, a lot of times people are like, well, no, it has to be strictly a blood relative, right? But it could, in Mississippi, it could potentially be an in love or in law. So when we're meeting with people, they readily say, well, yeah, mom had 5 kids, but they don't say that dad potentially had, you know, other children, or somebody was married. One of the children was married. And they left a surviving spouse. Well, that surviving spouse may have a right to inherit. And so that's why the prevention piece is important. That's why estate planning is important, because when you fail to plan, state law decides versus you having that control. Again, we've already talked about intestate, meaning just lack of a will. Of course, all of you know, as real estate professionals, that title is just the legal term that denotes ownership of property. And the key thing in terms of heirs property that we're always able to look at to determine whether or not one has heirs property is we look at the language of the deed. That deed is that legal document that's going to transfer title from one person to another. For us, if that deed says, you know, to husband and wife, you know, as tenants in common, heirs property. If that deed said as husband and wife with joint tenants with full rights to survivorship, it's not heirs property. And because if it says that with joint tenancy with full rights to survivorship language, what that means is at husband's death, wife 100% owns the property. On the flip side of that, if it just says as tenants in common or doesn't say anything, but just says it's husband and wife, in most states, that's generally without that specificity of joint tenants with full rights of survivorship language is going to be treated as tenants in common. You've created heirs property. And so if husband predeceased wife, we now have to determine who, you know, who is entitled to husband's 1/2 undivided interest, and wife still has her 1/2 undivided interest. And so it just can become a complicated mess, to be honest, just depending on the number of generations that pass. Additionally, in terms of heirs property, a lot of times you'll hear people say, well, heirs property is cloudy title or has a lack of clear title. That just means basically the deed is going to remain in the name of the original ancestor who owned the property until direct legal action is filed with the court. Now, common problems or legal implications as it relates to heirs property. One of the things about heirs property that makes it so very vulnerable is that the decision regarding land use generally requires agreement of all the owners. Now, we know it's difficult for 2 people to agree, let alone 10, sometimes 50. Sometimes we deal with families that have hundreds of heirs. It's difficult for everybody to get on the same page. We have some family members who want to sell the property. Others want to live on it. Others want to farm it. So everybody may have a difference in opinion as to what should happen with the particular problem. We've seen a lot of families, unfortunately, faced with foreclosure. And we've had to file temporary restraining orders, preliminary injunctions to try to get families or prevent them from being homeless. But heirs property, there is a high risk of foreclosure. It's very difficult to borrow money to repair the property or even obtain homeowners insurance. You'll have a lot of insurance companies that will not insure heirs property. What we also know, and this is a problem with heirs property, is that some family members will pay their share of taxes and maintenance, others will not. What I've seen in my 20 plus years of practicing law, you generally have 1 or 2 people who foot the bill to pay the property taxes and the maintenance on the property for the benefit of everybody else. But then those people and the everybody else, quite honestly, don't really want anything to do with the property, don't take financial responsibility for the property, but won't deed their interest or convey their interest to you so you can have the property, right? So it further complicates the status. Governmental programs cannot qualify. Value of the property is diminished for sale or leased because of heirs property. And then one of the biggest challenges with heirs property is this forced court order sale, or it's called a partition. It's a sale of the entire property. Now, this particular slide just provides a visual of what it could potentially look like, right, as heirs property landowners. And this particular slide kind of has Angela Johnson, let's say she's mom, and she has 4 children, 3 sons and 1 daughter. Each of her 4 children are deceased. So that first generation, everybody is deceased. At Angela's death, let's say all of her children had a 1/4 undivided interest in her property. Well, we know that all of them are deceased at this point. So now we have to determine who have a right to inherit from each of the children, where each child had a different amount of heirs. So son number 1 had 3 kids, son number 2, 4, daughter only had 1, and I believe son number 3 had 5 kids. And so you see how they start off. The first generation starts off at the same fractionated interest, but then as you go through the different generations, you can have deferring interest. And as an heirs property landowner, it doesn't matter if I have a 1/4 undivided interest or if I have a 1/6 undivided interest. We're still on the same playing field. And sometimes I think it's a myth. People believe that, well, you know what, I have 1/2 undivided interest, and so I have a larger say. That's not the case. That's a myth. With heirs property, all heirs are on the same playing field as it relates to the property, and everybody has an interest in the property. And so you see how we can have the same or we can have deferring interest, but we all have an undivided fractionated interest in the land. Now, when we talk about heirs property and, how do we resolve it? I've heard Attorney Barnes talk about the issue, talk about the problem, how it's created. Well, how do we resolve it? Oftentimes, we have family, and everybody I think has in their family people who just aren't connected to the property or the land and don't really have an interest in it. And those individuals actually can convey their property to you or someone else that they want to give that property to. They could gift it, they could sell it, but you can consolidate title and reduce the number of heirs for folks who don't have an interest in it, right? And so we draft deeds all the time for people who no longer want their interest and they want to convey it to somebody else. In many states, of course, you administer a probate the deceased estate. If a person had a will, you take the will to court for it to be declared the last will and testament of the deceased individual. It's a legal proceeding called, determination of heirs. You have a quiet title action. Put back up here family education, because that is really important. One of the things that we try to do is provide family presentations because we recognize and understand that the dynamics of families are different. And sometimes it may just be the person in the family who's bringing the information to the family that people are like, oh no, I'm not hearing it. But if you get a third party, unbiased family member to come to the table to just provide information and the law, we often find that many times family conflict is resolved, right? So family education is important so that people understand what they own, what their interest is, and what the law is in reference to it. Partition in kind or partition by sale are 2 different types of partition, and we're going to get into partition in a few minutes, and then the Uniform Partition of Heirs Property Act. So these are ways in which heirs property can be resolved. But quite honestly, education is very important, but what moves the needle forward is direct legal action to help clear title, right? So you need education, but you also need an attorney to go to court on your behalf to help resolve those title issues and clear title to the property. And so if it's an estate administration or a suit to determine heirs, one of the things that I wanted to point out here is that each state statute is going to state what has to happen in terms of processes, right? But typically you have to provide notice to known and unknown heirs. And so that means either people sign waivers or joinders or they have to get personally served. A lot of times what we find is sometimes because of the Great Migration, families may not always know where their family members are located, right? So family members may be unlocatable. Family members may not, you may not know this set. And so, but, you have to show the court that you've had due diligence and you've done your best to locate them, because courts do not want to divest people of their interest in property. But I just want to just put a plug here that in terms of notice, that family tree is very important, because you're trying to determine who has a right to inherit. And we need to make sure that we notify those people who have, that we know. And then the court, the statute may also say it's a procedure that we have to notify folks who are unknown as well. Now, what we've seen in terms of challenges in resolving heirs property is determining heirs is one of the biggest issues or barriers to resolving heirs property. And then family disputes, like determining heirs and family disputes and working through family dynamics can be very challenging when trying to resolve heirs property. I will say this: sometimes people are like, okay, well, I know I have heirs property and I'm ready to go. And they want real fast, real quick, right, real hot, and right now. Well, that's not, my heirs property is a topic that's not like microwavable. You don't put it in and try to resolve it in 5 minutes or less. We have resolution, right? That's just not it. Quite honestly, I've seen deeds all the way from like 1900. And nothing has been done to resolve that title since that original conveyance. So that's generation on top of generation that you're going to have to unwind to try to clear title. And so quite honestly, it's a process, and it may take some time, right? And so determining heirship and family disputes, however, are the biggest challenges I've seen with trying to resolve heirs property. The vulnerability of that forced sale, and then that difficulty accessing resources come in third and fourth place. Now, in terms of, I briefly mentioned partition. And one of the things that's very important is learning about the Uniform Partition of Heirs Property Act. This particular act is very important because it contains legal protections for heirs property landowners. It's going to provide specific guidelines on how heirs property is partitioned. And the state of California actually enacted the Uniform Partition of Heirs Property Act into law in 2021, and it became effective as of January 1st, 2022. And then I think in January of 2023, it was incorporated as a part of the Real Property Act. But this particular act is important because it provides 3 major provisions to heirs property landowners. Now, prior to this particular act being an act, when, let's say, for example, you have a family and your brother, right, wants to sell his interest. Nobody is saying that, and everybody else is like, no, we want to keep it. So he goes to court and he files a partition by sale action to force a sale of the entire property. Well, prior to the passage of the Uniform Partition of Heirs Property Act, what typically would happen is it really didn't matter if you lived on the property, worked on the property, farmed the property would be sold. Most often than not, prior to the passage of this particular act, family wouldn't receive notice, or if they received notice, it was at the 9th hour. This particular act tries to safeguard and make sure that heirs property landowners, if there is going to be an action filed to force a sale of the property, that they receive due process and notice. And it's going to provide 3 major provisions. The first one is the buyout provision, or the right of first refusal. So if I'm an heirs property landowner and somebody, my brother wanted to sell his interest, before he can sell it to a third party non-family member, he has to offer it to me and the other siblings, right? So we have a right to buy out his interest, and that way we still maintain it in the family, right? The next major provision is an open market sale. As real estate professionals, that's good to know, because what it does now is it treats it as a traditional real estate transaction. And you have a broker who is now assigned to the transaction. If the family cannot agree on, the appraised value, they can get an appraiser, right? Who can be appointed to come in and assess what the value is. Additionally, there is this enhanced notice provision that makes sure all all heirs are notified of the action. And then lastly, in terms of the three major provisions, is a preference for a partition in kind. Now, partition in kind is just a physical division of the property where you have a surveyor to come out, and let's say it was 100 acres, and so they subdivided into, let's say, 10 parcels, and you have a separate legal description for each of the 10 subdivided parcels, right? That's a partition in kind. And then you have a partition by sale, which is a forced sale of the entire thing. So what this law basically says now is courts are going to have a preference for, if it's practicable, partitioning it or dividing it in kind versus selling the entire property, right? So there's this preference for a partition in kind, and courts look at the totality of the circumstances. They look at the non-economic and economic value of the property. So if I lived on the land, if I paid the property taxes, if I've done the maintenance, if I farmed it, whatever I've done as it relates to the property, if I'm just connected to the land, right? The court is going to consider that in addition to its economic value. So the Uniform Partition of Heirs Property Act is a great tool that Californians have in an effort to help protect their legacy and maintain their property. I'm not sure how it is in California, but I know in Mississippi, we passed it July 1st, 2020. And as I sit here today, there are many landowners in Mississippi who do not even know it exists. Right. And so what we are tasked with doing is making sure, we get the word out so that people are knowledgeable, that they do have help. Right. So this is the Uniform Partition of Heirs Property Act. And again, California does in fact have it. Now, when we think about prevention and what can we do, right, to help us in terms of legal structures that may help us hold the land. Let's say once we get the title clear, what can we do? Well, we know we have a trust as an entity or tool that we can use in our toolkit. We can form a limited liability company, or we have what's called a tenant in common agreement. So when we think about a trust, what owners are able to do is transfer their interest in the land to the trust, and then you name one or more people to serve as the trustees, those persons who are going to manage the trust. And you have a trust agreement that speaks to how the trust or land, how the land is going to be controlled, who's going to manage the land, who's going to be responsible for maintenance and taxes. And that's all set out in the trust agreement. And so the limited liability company works similarly because the operating agreement is going to dictate, right, what happens as people transition, what happens to a member's share when he or she dies, what happens if a member wants to sell, who makes the decisions. All of these things are important if we're talking about how we preserve and prevent the creation of heirs property, right? So just knowing that there are legal structures that are out there that can hold land, or you can have as a tool in an effort to try to avoid this heirs property quagmire. And then the last one I'll just briefly mention is the tenant in common agreement. With a tenant in common agreement, the legal structure is going to remain the same. Everybody that is an heir just agrees on the responsibilities, who's going to manage, how the property is going to be, property taxes will be paid, how the property is going to be used. If somebody wants to sell their interest, what that looks like. And I can maybe try to provide President Wilson and the team with maybe some sample tenancy in common agreements, just so that you all have them and know what they look like, and they'll be applicable for California. But people sometimes, families are able to sometimes agree. And as a family, you can just agree to what that looks like. But when a family cannot agree, you may want to say, well, let's put it in a legal structure. And we have an agreement, the trust agreement, if it's a trust, or an operating agreement, if it's an LLC, and that will govern how we manage and operate those particular structures and our interest in the land. Another, I think that I didn't put on here, but another vehicle that we often use are deeds. And so one of the things that I told you all earlier that I could not get my grandfather to allow me to draft a will or go to somebody and get a will prepared. But what I did do is I was able to still get him to estate plan, notwithstanding the fact he didn't have a will. So what we did is we did a partition in kind of his land, and he and my grandmother were able to gift that via a deed to their children during their lifetime. So at his death, there was nothing to fight over because we had already gotten rid of all the realty during his lifetime. You also have something called maybe a life estate deed that where you can convey the property to, let's say, your child or children, and you retain a life estate, which means as long as you live, you own the property. At your death, it goes to them, right? Some states now have what's called a transfer on death deed, where you can list in that deed who you want your beneficiaries to be, and that bypasses the need for probate, because probate can be costly. Quite honestly, probate is important, but when you're thinking about estate planning and the different costs and balancing what your goals are and what your strategy is, those are all things that you need to consider. But let me ask this question, and I want y'all to put this in the chat. This is the question, and then we'll talk about estate planning. To prevent heirs property, all you need is a will, and that's yes or no. To prevent heirs property, all you need is a will. Put that in the chat for me. All right, I see some no. Okay, I see majority no's. I don't see any yeses yet. Okay, all right, good deal. All right, and so of course it wouldn't be anything other than in Lori Lee fashion for me to say it's yes and no, right? Yes, a properly executed will that is written according to state law that divides the land into specific acres or parcels can secure title to the land from one generation to the next. However, a will is not the only way that property can be transferred from one generation to the next. And of course, I just gave the example of my grandfather, right? So you need, right, a will. I think a will is very important. Now, one of the things that we know in terms of heirs property is that I looked kind of at the stats, and I hate I didn't put it here, but when I looked at the numbers in terms of how many people get wills done, right? It was still low amongst African Americans. Now, I see come in here in terms of a trust. Now, a will and a trust is important, but not everybody wants a trust. So it depends on what your goals are. Typically, what we suggest is, if you're gonna have a trust, then have a will, right? Have a trust and a will. So the will serves kind of as like a pour over will. So if you did not fund something in your trust, or you later acquire property that is not listed in your trust, then your will has that residual clause that would then say it goes back to the trust. Anything that I own, real property or assets that I own at my demise, I want to go to my trust. So if you're gonna have a trust, the suggestion is to have a trust and a will. But depending on one's assets, depending on one's goals or wishes, they may not want a trust or may not need a trust. They just may need a simple will, or they may be able to, notwithstanding having a will or a trust, still divide or transfer the property during their lifetime. But when we talk about estate planning, I put this picture here of this lady looking at the water, because peace is priceless, right? And I like to say, not say estate planning, I like to say life planning. Life planning is important, because what we've learned today is when you fail to plan, the state determines who has a right to inherit. And I don't know about you, and I believe that you, like me, have worked really hard, right, all of your life to amass assets. And you want to be able to determine who gets those assets, right? Not the state. And so in order to do that, it's important that you begin to plan, and you have an estate plan that speaks to what that looks like, so that you can control what happens to your assets during your life, but then you also can control control what happens at your death, right? And so an estate plan is very important. And so, of course, when you think about estate planning, you think about setting goals and then using those legal tools and strategic plans to meet those goals. And it looks like, I think somebody said in the chat that in terms of California, that you need a pour over will, and you need to avoid probate, a living trust. And so each state is different in terms of ways in which you do it, but these are mechanisms that you can use. A will is important and a trust is important. You just have to know, and this is the thing I'll say here too. In terms of speaking with a lawyer about estate planning, you need to, I would suggest that you speak to a lawyer who this is their area of specialty, right? Not necessarily just a general practitioner who does wills, but a lawyer who is very familiar with estate planning, estate taxes, right? Medicaid, because as you age, you want to make sure that whatever you do does not adversely affect your ability to qualify, right, for Medicaid or long-term nursing care. So all of those different things, you want to speak to your financial planner, but you need to make sure the attorney is an attorney that this is the work that he or she does, right? So that, because what I've seen, quite honestly, is people go to attorneys with the intent of not creating heirs property and preventing the creation of heirs property. And what they in fact end up doing is in fact creating heirs property, right? And so they would have spent all this money and time with a lawyer to still be in the same position had they not gone to a lawyer, right? And so it's very important that you communicate and consult with someone who is very familiar with estate planning and what that looks like. Now there are these are like the basic estate planning documents. We kind of mentioned a trust, but a will, of course, we just know a will directs how your financial and physical assets are going to be distributed at death. Now a living will, a lot of times people get that mixed up with a last will and testament. A living will is really known as your advance directive, and it states your end of life wishes, right? Whether or not you want to be resuscitated, like what those things look like, that's your living will. And then of course you can have a power of attorney where if you become mentally or physically incapacitated, that you already say who you want to manage your assets and affairs and be like that proxy for you in the event you're not able to do it. And quite honestly, as I sit here, that's one of the things, like my dad will be 78 this year, my mom will be 74. And although they're in pretty good health, we're thinking about as they age, we need to already have, and really should have already had it, to be honest, a power of attorney, right? So that in the event something happened or they became mentally or physically incapacitated, we'll be able to act on their behalf. We'll be able to speak with medical providers. We'll be able to get access to financial documents and records in an effort to still keep things flowing. So these are things just to consider as you think about the estate plan and what that looks like. And I know all of you, and I'm looking at my time. Okay, I know all of you have kind of maybe have had conversations about like estate planning, right? And estate planning with your clients, and some of you maybe talk with your clients about estate planning before purchase, or estate planning after purchase. But I think it's very important that we navigate the conversation and we have those conversations, because when we fail to have the conversations, we just perpetuate the cycle of creating, right, cloudy title and tangled title, and people increasing really the racial wealth gap, because we know realty is a way to build wealth, and when one is not able to do that, then that is not helpful. So let's kind of talk about, as I end and open it up kind of for questions as I get ready to conclude, how or what can we do to kind of help stabilize, right, land ownership for economic stability. And again, I think having the conversation is important, and thinking about goals of the family, goals of the individual. What is it that I see? What I'm seeing now, though, is whether you live in a rural area or urban area, there's now this big push to kind of getting back to the land and doing some like gardening and growing things with one's hands. And so just thinking about, well, what does that look like? I've seen a lot of people contact us because even though we're in Mississippi, a lot of our clients are out of state. As long as the land is in Mississippi, we can represent them. And so they're like, listen, I'm getting ready to retire and I want to come back to the South, right? And I want to be able to get on the land and work the land. And so you need to think about just planning, right? Life planning. What is it in terms of goals that you want to do, and what do you want to get out of the land? What do you want to see? How do you want to position your legacy, your heirs, in reference to this generational wealth and unlocking that potential? And then thinking about the family dynamics. We talk to people all the time. I know I have 3 sisters. It's 4 daughters. And although my sisters and I get along, you know, everybody is strong-willed, and so we don't always agree, right? And so our parents, if they're like your parents, may be like, well, I want everybody to share and share alike. And I'm like, no, parents, don't do that, right? Because when you do that, you create heirs property. So you may need to think about the family dynamics and what that looks like and who gets along with whom. Or maybe, you know, instead of giving one child land, you give them money, right? But just thinking about what that looks like in an effort to avoid that. And then, of course, the estate planning piece of wills, trusts, LLCs, creating that family tree. And I know all of you are very familiar with the title search. And one of the things that we always get done before we ever file any type of action on behalf of heirs is a title search to confirm ownership of that property and identify any defects with the property. A title search is very, very important. And I'm sure in your line of work, that's typically when you find out your client, there's an issue, right, with the title as a result of the title search that was ordered by most of instances, the mortgage, the financial lending institution, right? Whether that's a bank or a mortgage company. So the title search is important. And with those title searches, though, if you know, we can help people get ahead of the game in terms of, let's listen, document. I know years ago, when I think about like my great grandparents and my grandparents, like my paternal grandmother is 96. They put family business in the Bibles, in the front of Bibles. They put, you know, birth dates and dates of deaths, right? But just going back to our roots and our lineage and our heritage to bring back the family unit and structure, and to just know with whom we are related. Now, they do have a lot of genealogy sites now out and that help with that, like Ancestry.com and others, and we can provide a list of those as well that people can use to help like trace and track down people. But in terms of resolving this heirs property quagmire, the family tree is really, really important. So the last thing I think I'll say before we open it up is I always put this sign on here about our cultural lens, right? Cultural sensitivity. What I know about working in this space is that we deal with a lot of seasoned landowners, right? And so because I know that trust is a barrier, we always want to make sure when we're communicating with clients or with family or whomever that we don't unintentionally offend. And so a lot of times we say, even if, you know, a person is 60 and the landowner is 70, in the South, it's this unspoken expectation that we approach people and address people with yes, ma'am, no, ma'am, yes, sir, yes, sir. And so even though we're all grown, because we don't want to unintentionally offend and we're trying to reach the end goal, we recognize and see it through that cultural lens to know I still need to say yes, ma'am, no, ma'am, yes, sir, yes, sir. So in your respective areas, whatever those cultural sensitivities are, it's important that we're mindful of that. And when we're engaging in conversation, in order for us to really move the conversation forward and help resolve this heirs property issue. Paying property taxes, having that valid will under trust, making a family tree are ways to avoid it. I did see that the legal assistance collaboration in California is an entity that does assist and help people in times of natural disasters, in terms of resolving title. I didn't find a whole lot of others, but I am a member of the Heirs Property Practitioners Network. And so I'm going to put an inquiry out to see if we have any of those members who may be practitioners in California, to be able to provide you with that information so that you all have a resource when you encounter heirs property issues, so that you have people that you know who practice in this area who are able to help. This is, and then the last thing I say, and I know I said that 100 times, but I promise y'all not gonna be happy to see me and then to see me get on this Zoom and happy to see me get off. So I promise you, I'm wrapping up. In terms of other resources, there are just some general information about heirs property, and there are some state-specific fact sheets with the Farmland Access Toolkit, and then the Conversation Project is a good tool because they actually have starter kits on how to start the conversations of the power of attorneys, of estate plannings, of wills. And so I put that here as well as a resource, so that as you think about having those conversations with your clients, this may provide you with some insight on ways in which you can do that. And as they say, and finally, right? My contact information is listed here. This is actually my direct dial and my email address. Of course, our time here is limited, but if there are other questions or other things that you want to communicate with me about, or feel free to give me a call or send me an email. I'll be more than happy to assist you. So I'm hopeful that during our time together today, I gave you a view of what heirs property is, how we protect it, how we prevent it, in ways that you're able to continue to strengthen your communities and help landowners in your respective states. Again, thank you so much for the opportunity to share. Always humbled and honored to talk about all things heirs property and land.
Oh my goodness, my goodness, my goodness. Mind blowing, fire hydrant, over the top, just outstanding, outstanding, outstanding. We want to take this time now to open it up for questions and answers. I was trying to sit here and think of questions that was in my head, but every time I thought of something, Attorney Barnes answered the question. It don't mean I'm gonna remember what she said, but she did answer the question. I need to just listen to this about 75 more times, but I'd like to open up this time for you to ask a question. If you have a question, you may type it in the chat or you may unmute yourself and ask your question. I see a hand. I see Renee Roque. She's going to start us off. So unmute yourself and fire away. You're muted. Unmute yourself. Oh, wait, you can't. Hold on. I had to mute y'all, not let people unmute. Let's try it. Let's see.
There we go. Thank you.
There we go.
First of all, there we go. I think we're done. Good? Unmute it. Can you hear me? Thank you. Andrea, thank you for your presentation. I love how God leads us to our mission and purpose from our pain or our family, and then we figure out our purpose. So I love that. Thank you so much for sharing. President Mel recently had an initiative because 200 of our people here in Los Angeles area were displaced because of the fires. A lot of the people, I think 4,700 homes, single family residents were burnt in a community called Altadena, which is mostly, you would say mostly a Black community. And now as we're trying to help people, we find that there weren't deeds. They were just told it belonged to them. You know, mama died. And any advice for us as we are talking to people, trying to help? Someone said earlier they were helping, you know, churches have been coming together. Any advice for us in locating deeds, trying to go back where heirs are? Anything that we can do to help? We'd appreciate it. Thank you.
Okay. Yes. So most deeds should be these should be in the county court land records, and so you should be able to access them. And quite honestly, depending on the county, you may be able to go online and do like what's called a land roll query, and you type the person's name in, and the parcel may come up, and it may tell you the book and page number of where that deed is recorded. Sometimes you're able to get it online. Other times you have to go down and actually go to the county courthouse to actually get it. It just depends on the county and whether or not they allow you access online. But that's one of the things that that you can do, quite honestly, especially if everything was destroyed in fire and they don't have it. And that kind of happened here 2 years ago with tornadoes in the Delta in Mississippi. Devastation, homes to the ground, right? Nothing there. And so that's what we tried to stand up Operation Recover Rebuild, where we went to courthouses to try to help people find those deeds. That's the best way, I think, to do it, because if in fact there is a deed in terms of ownership of that property, it is going to be filed and recorded. And so going there to get it. Now they may make you pay maybe a nominal fee for copies, but you should be able to get it. And you may, like I said, if it's a county that allows you to have access online, you can just print it. You can sit at your computer and just print them off.
Thank you so much. Thank
Outstanding.
you.
Shelley, not Shelley, Mona has a question, and her question is, do the wills ever need updating?
Yes, yes, yes. Because life changes, right? And so, you know, a will that you would have done 5 years ago, maybe someone that you left as a beneficiary is no longer here, or maybe your marital status changed. You may be single now, and 5 years ago you were married. And so the suggestion is to look at your will every 2 to 3 years, so that as life changes, you're making sure that you update your will to be consistent with what's going on in your life.
Outstanding, outstanding. All right, we have 16 minutes, guys. Don't be shy. If you have questions, here is the time to ask your questions.
And I think somebody asked about the organization for
And
legal
to-
assistance, and that was Disaster Legal Services California.org. And it's a statewide alliance of, I believe, private, public, and nonprofit organizations that provide free legal assistance to communities who have been impacted by disasters throughout California.
Outstanding.
Yeah.
I have
So,
2 more
Can
questions.
you put that in the chat, please?
I'll put it in the chat right quick.
I have a question from Ronnie. Ronnie says, and then I see a hand. The first question says, for the will or the trust, does it require an attorney to revise the will or the trust?
I would say yes. And simply because laws change as relates to statutes change, laws change, and I would always defer to going to an attorney to have anything updated or changed as relates to a will or trust. Because in many instances with the trust, you have to file in Mississippi, it's called a certification of trust or a memorandum of trust in land records. The actual trust agreement is not filed, but that may change, or one of the named trustees, right, may die, and so that now it's time for the successor trustee to take effect. And so my suggestion is always to consult legal counsel in reference to that, to just ensure that you have what you think you have, and that you have what you need.
I agree with that 100%. I see Kevin has his hand up. Kevin, you may ask your question.
Actually, mine's not a question. I want to thank you, Andrea, because you have the Hallelujah Choir over here. You were
Yes.
down near Jackson, Mississippi. Is there in Jones County. Related to some folks that got some stuff in this big old mess you're talking about. They have streets named after this family.
Wow.
This is how long the legacy goes back. In addition to that, I'm listening to you talk about the frustrations of estate planning and these deeds and such. It is all about the paper trail. I'm a financial services professional myself. I've been active since 1989 when I became a real estate agent, a broker in 91, and I've run my own business for more than 35 years. One of the realtors, bank, broker friend told me about this because of what I do for a living. What I do is estate planning and asset protection. I do all the corporate structuring for the LLCs for the real estate properties. I do the living trust and all of the components, including the certification that you speak to. I've dropped some comments into the chat because this is what I do. I'm glad to hear you speaking it the way that you have, giving insights to the frustrations, because it is a long, drawn-out process. If you don't do it right, you could be tens of thousands of dollars, like I am currently. And I'll close on this. My mother died 1 year ago next month. 2 weeks after she died, it started. There is already a $700,000 house next door to the $700,000 house. They've already taken that one. the money out of the trust account. The things that are available to criminal-minded individuals, let's just say it politely, just like we go to work to help people buy and find their homes and sell things. Criminals go to work every day, folks. Please believe me, they're sitting around finding ways to tie up these properties. And as we know in California, and I'm here in San Pedro, Southern California, as we know, if we can't get insurance, even if everything's perfect, you still can't close escrow. So I hope that, you know, the enlightenment that you had hoped you shared is also received by all the other folks here on the line, because you got the hallelujah choir over here.
Oh, thank you. You're too kind.
No, I'm absolutely serious.
Thank you so much, Kevin. I see Yolanda's hand.
Yeah, Andrea, I wanted to ask you a question regarding families. So let's say the mom leave a trust, but all the rest of the kids don't know what a trust is. And the one person that knows what a trust is and know about the trust is not sharing with the other family members. Have you ever had that situation?
I've not had it in reference to a trust, but the thing about a trust is there should be a certification of trust, a memorandum of trust that's filed in land records. At least I know that's how it is here in Mississippi. And so if there was a trust agreement, or if there is a trust, you should be able to find that in land records. And the trust, the memorandum of trust, the certification of trust is going to at least have basic information in terms of who the trustees were named to be, the successor trustees, and you know, some of that. If there is land that is within that trust, then that certification of trust or memorandum of trust should state that, right? So it's not going to give you everything in terms of agreement. There are key things though that it's going to let you know that is there that suggests that yes, mom did have a trust, and I can show you what I pulled from land records, right? That tells me that she had it and she named you as a trustee. Where is the trust agreement?
So do anyone on the line know in California, do we have that here?
I don't think so, because I've run up against where the family said, mom said the trust is in this chest, and it wasn't there. And then they try and figure out who the attorney was, and he might be dead or she may be dead too.
Exactly.
So there's a major problem. I don't think it's required here that we certify, what do you call it? Record the trust, but it should be.
Actually, we do not have to record trust here in California. Just went through this with my husband's father's death, looking for the recorded trust, then don't know who the attorney was. So they are not required to be recorded in California.
That is correct.
I wasn't sure. I've been looking, but I haven't seen anything where the trust is actually being recorded. I know the deed is recorded in the trust, but the actual trust documents, that's where we're having problem finding the document.
If you don't know what attorney drew that up, you are out of luck.
Well, no, we don't know the attorney either.
We just had a case not too long ago. I see one of my team agents is on the call, and we were just praying to Jesus that the seller actually found the trust, and he looked and looked and looked and looked and looked and looked, and by the grace of God, it took a long time, but he finally found it, because otherwise we were dead in the water.
Yeah, that may be something for a policy consideration, because not
very
necessarily the trust itself, but at least a memorandum that kind of has bare bones information that is filed in land records, because that protects, right? And families are able to then know who the lawyer is, you know, who the trustees are. And so that may be really something that's ripe for a policy.
I agree. Rosalind asked, is the attorney who prepared the trust required to record it anywhere? Is that anywhere in any state, even though it's not here in California? Is it anywhere?
In Mississippi, what's recorded is, like I say, the memorandum of trust, right? And that is recorded in land records. So because it comes a part of the chain of title, especially if real property is involved. Yeah, you file and record the deed, but in addition to filing and recording the deed, you file the memorandum of trust. And so that is the evidence that a trust was actually created.
I like that. I like that.
Let's work on some policy.
Exactly. I
Yeah.
would like to return the presentation to President Mel for his final remarks and closing statements.